My His Lordship, may I take the indulgence to allow me to move one matter tomorrow. We are fighting today is a promotion matter. Whatever is this, my lord, in the MIDC, Meghalaya Industrial Corporation.
Promotion are right.
My lord, the impinged order was issued on 25th, and we are my junior has superseded me.
Already superseded. Then what's the urgency?
But if they are yet to take over, then Lordship may kindly see.
Promotion, Mr. Chakreso, is not that you're being evicted or something. It'll come usual course. Let it come after tomorrow. No problem. Okay. Yes.
My peace, Lordship. My Lord, I'd like to mention item number 30, my Lord, on behalf of the petitioner. Mr. K.P. Bhattacharjee is the counsel for the petitioner, my Lord.
Number?
Item number 30, my Lord.
30.
My Lord, hearing.
Yes.
My Lord, Mr. K.P. Bhattacharjee's wife met with a minor accident this morning, so he has to attend him, my Lord.
Okay. The Pacific 2 weeks.
My Lord, highly obliged.
May I please, Your Lordship, I beg to mention item number 25, Your Lordship. 25. Let this matter be taken after 2 weeks, Your Lordship.
Where's Mr. D? Still on leave?
No.
Then?
You're not ready, man. I just...
Too many adjournments, Mr. D.
After 2 weeks, we'll do it. I have taken concern of the respondent also.
2 weeks. You for respondent?
Yes, Your Lordship.
My Lord, 25 will be connected with item number 1, my Lord. Jesus, all please hold together.
1?
Yes, my Lord.
Number 1 of today's list.
Number 8.
Number 8?
My Lord, number 8, my
Oh.
Lord. You take the matter, my Lord.
No, it's not connected. It's not connected.
It's on a different footing and it has
No, it's not connected. It's not connected, yes. Yes, Mr. General.
Lordship, it was regarding number 8. As Lordship has observed, these are not connected matters.
Yes.
Lordship, I beg to mention item number 34. Lordship, we're making a joint prayer, Lordship.
2 weeks.
2 weeks, here.
2 weeks. Yes.
Obliged.
Obliged, Lordship.
Your Lordship, I beg to mention item number 26, Your Lordship. The matter can up tomorrow or any other dates.
You on whose behalf are you mentioning?
Respondent 5, 6, and 7.
Who responded 5 and 6?
The
Who's your leading counsel?
Sergeant Residential.
Yes.
Lordship, 5, 6, 7 are the private respondents. I'm slightly indisposed today, my Lord. If this matter can be taken on any other date, my Lord.
Yeah, 1 week.
Obliged.
Much obliged, Your Lordship.
Hello.
May I please, Your Lordship, I beg to mention item number 32. Kindly list this matter after 2 weeks, Your Lordship.
You're appearing for whom?
For respondent, Your Lordship.
Lordship, in this matter, we had made a mention on
The GST is being cut or something. You wait, let the matter be called out. Because they mentioned it especially that will be taken up today. Last week, okay? You wait. Don't go anywhere.
Highly obliged.
May I please, Your Lordship, I beg to mention item number 29. I'm mentioning on behalf of Ms. O now.
What's this number 29? It's just been, there's nothing in the case anymore.
His Lordship, the arguing counsel is out of station, Your Lordship.
Doesn't matter, they've changed counsels. You're here, we'll do it. You're there, doesn't matter.
No.
Then why are you mentioning it?
I've just been informed by the arguing counsel, Your Lordship.
1 week, yes.
Your Lordship.
item number 1.
Have you corrected the defects?
So we want to withdraw and file fresh with liberty to file fresh.
Okay, Ms. S. Rahman, please be allowed to withdraw this due to certain defects incurable. Please that please be allowed to withdraw this instant matter with liberty to file afresh. is to advise. Praise allowed matters post withdrawal will deputy as prayed.
Item number 2.
May I please, Your Lordship? Lordship, through this petition, I am praying for payment of death cum retirement benefits in respect of petitioner's husband, who retired in the year 2016 as a deficit teacher and subsequently died a year later in 2017. Despite representations, nothing has been paid as yet.
Yes.
Despite many representations and physical visits, nothing has been paid.
Where's the representations here? Next time here?
Yes, Lordship.
They haven't responded at all.
They have not.
When was the first representation?
Page number 26, I beg your apology, Lordship. Annexure 9.
When did you retire? You retired on?
2016, Lordship.
2016. First representation you wrote 22.
Lordship, we had made physical visits to the office and they had asked us to wait. They kept on telling us to wait, but then finally we had to resort to this representation, but then they haven't replied as yet.
He died?
He died in 2017.
Yes, but Mr. Pandey, issue notice, you'll accept this
1 and 2, my lord. Mention
MS
committees.
Arconi, the GA accepts on behalf of 1 and 2. Petition 6 steps for service notice remaining respond within 3 days. Just after 3
Highly
weeks
obliged.
for affidavit.
3.
Please, Lordship. Lordship, this petition is for the release of the retirement benefits in the
How many months?
Your Lordship, Mr. Sen is on sanctioned leave, Your Lordship. So I pray that the matter may come up after 10 days. He'll come with instructions.
Yes, sir, Mr. PD, issue notice. MSZ Kendri is present on behalf of the Vice, Mr. S. Sends present have respondents. This is a matter of the 10 days for instructions.
There are 4 cases,
3,
Lordship.
4,
Yeah?
5, and 6.
3, 4, 5, 6.
See by this one.
Obliged.
Obliged, Your Lordship.
7.
Mr. Manta?
Maybe please, Your Lordship. This is a matter that we are challenging the SOP issued by the state government. And the SOP has been issued without any power. And it is in violation of the MMDR Act 1957, Your Lordship.
How do you say that? Where's the SOP?
SOP is Annexure 1, page 27, Your Lordship.
Okay, what you agree with which part of this notification?
I am aggrieved by the page 33, Your Lordship. Page 33E, capital E, miscellaneous.
Miscellaneous, okay, yes.
15, that an application for mining list shall be for an area not less than 100 hectares. Not less than 100 hectares, that is in violation of the section 6 of the Mines and Mineral Development Act. I have a copy.
Is in violation of
section 6.
Yes.
Maximum area for which a prospecting license or mining lease may be granted. One, all this year given, not clause A, one or more prospecting license covering a total area more than 25 square kilometers. So let me come straight to C, clause C, Your Lordship. Any reconnaissance permit, mining lease, or prospective license in respect of any area which is not compact or contiguous. Is there any area? Cannot be less than 100 hectares. So this is their take it to monopolize the whole business. So small miners
come again. Maximum area for which a prospect license may
Yeah,
be granted. No person shall acquire respect any mineral prescribed in a state. Any reconnaissance permit, mining lease present in respect area which is not compact or contiguous.
Yes.
Meaning that it has to be in one area only.
One
right?
area, any area, but it has to be one. So
Yes.
that
So
is
what do
not
you-
in
what do you
consonance with
agree?
this. 100 hectare cannot be not less than 100. That means the others, those who are having less than 100 hectares, are deprived of.
No, not which is not compact contiguous. Where did he say the area? Does not say area here, anything.
Here,
Section 6.
area, A says that one or more prospective licenses covering a total area of more than 25 square kilometers.
Then B, one or more mining leases covering area of more than 10 square kilometers.
Yes.
So you can't have more than 10 square kilometers. No. You can't have reconnaissance permit for more than 1,000 square kilometers.
Yes.
You can't have prospecting license of more than 25 square kilometers. 100 hectares is 1 square kilometer.
That comes to about 200 some acres.
It comes around 250 acres. Yes.
So I'm aggrieved by this, Your Lordship.
Aggrieved in which way, Mr. Manta?
I'm aggrieved because suppose I have 10 acres. So I'm also intending to go for mining lease.
Oh, that way.
That way. I'm deprived.
Why do you say that is monopolizing?
No, obviously, because less than 100 in hilly terrain will have 200.
So where does the act say that you can give prospecting licenses for smaller plots? Does it say anywhere?
No.
You think that this notification is in contravention of the section 6, correct? So show that how does it violate the act? Notification.
No, not only that, the notification, the source of power of SOP has not been spelled out. If Your Lordship comes, it is not in consonance with the act because the source of power, if Your Lordship see, they have not spelled out the source of power. Under which source they have made the SOP.
No, it's what about the mineral concession rules?
They didn't give that source of
it's
power.
Silent.
Silent. That's the reason I have to fight this case.
Let's see that mineral concession rules, provisions.
Rules also there, Your Lordship.
Mineral concession rules.
Yes, 1960, Your Lordship.
This is which page is this? Chapter 3A. Where does they speak about prospecting license? Just come there.
That is chapter 3, Your Lordship. Here, 9. Application for prospective license and its
9.
renewal.
Yes.
An application for a prospective license and its renewal in respect of land in which the mineral waste in common shall be made to the state government in Form B and Form E, respectively, though through such office and authority as the state government may specify in this behalf. So, Your Lordship, then what happened, I'll tell you, Your Lordship can turn. I have applied for RTI, the petitioner applied for RTI, that at page 42. If Your Lordship is pleased to see. Page 42.
One second, Mr. Just 1 second, just 1 second. Okay, here we see.
So, RTI, the petitioner has applied at page 42, Your Lordship.
Yes.
Page 42, Your Lordship, to PIO. Then, under number 1, under what provision of law standard operating procedure SOP for not less than 100 hectares had been introduced in order to obtain a mining lease? Number 2, in what is the rate of challan for coal transport per ton? 3. What is the charge for entry fee of 12 and 16 will start for coal transportation, and under what authority of law, if any notification is there, kindly please furnish. And next page, answer, Your Lordship. Page 42.
Information.
In reference to your letter, so the subject, I am to inform you that the information sought by you from point 1 to point 3 are not available in this office.
Yes, government. Who's appearing?
Lordship, I'm appearing on behalf of the government, Lordship.
Where they say the 100 hectares is a minimum, correct?
Yes. Not less than. Page
Mining
33.
is prospecting is different, mining is different.
Lordship.
See, yes.
Because
And
I
then
have to apply.
reconnaissance permit
So,
different.
in
Now it's different. I think they have one permit for everything. If I'm not mistaken, no. Is that correct?
So I have to apply. Since I am also intending to apply, I don't have 100 hectares. It needs 100 hectares. In a hilly terrain, it's not possible to have 100 hectares.
No, it's very possible. Many places have 1 kilometer plots. Anyway, yes.
Lordship, at this juncture, I beg to state that I'll need time for instructions, Lordship.
Who are the parties here?
Union there, Khasi is there, Garvin is there, Jainti is there.
Respondent number 7, my lord.
Who's appearing for the union? Union is not here. Yes, I heard Mr. S.P. Manta, learned senior counsel, assisted by so-and-so on behalf of the petitioner. Issue notice, yes, MS NG Senior Advocate with Mr. H. Karvan Lang. Present accept notice on behalf of respondents number 124. Mr. Vijay Kanta on behalf, accept on behalf of 5. Mr. S. D. on behalf of 7 and Mr. M. on behalf of number 6. Just after.
Union is not there, sorry.
Yeah?
Union I haven't met.
Just after the central act, the minimum party. This after 3 weeks for instructions or affidavit, yes.
Much obliged, my lord.
Item number 8.
Please,
Yes.
Lordship, I pray that this matter may come up tomorrow or the afternoon. Lordship, if the matter can come up after day after, Lordship.
After the after meaning?
The day after tomorrow. Sorry. My
Mr.
apologies.
Jatal,
Lordship.
the hour of tomorrow then, since you indispose also. Yes.
Very well.
Or the request of counsel for the petition is matter the after tomorrow for admission.
9.
Much obliged.
Please, your lordship.
There is an application. My apologies. By way of an abundant caution, we had to file an application for condemnation of 5 days delay. I was not a party to the writ proceedings that were filed before your lordships. What had happened, is the private respondent came before your lordships, with a very innocuous prayer that there is an order of mutation, and demarcation passed by the revenue officer, to which naturally the district council also did not oppose, What was not brought to your lordship's notice is, there is essentially a title dispute that is pending before the authorities there. What had happened, is in the garb of, a mutation through inheritance, portion of my land, was taken into his patta. This fact was brought to the notice of the revenue officer by us, and after the order was passed, an appeal under the regulations has also been filed by us, but that appeal has not been taken up till today. Now, your lordships had directed, that within 2 months from the date of passing of the order, the demarcation was to happen and there should not be any obstruction to the demarcation. And pursuant to that, the district council has now fixed the demarcation on the 5th of May, that is Friday next. Now, what would essentially happen, is my appeal pending before the appellate forum, would be rendered infructuous in view of if any kind of demarcation is done, which is why we are before your lordships.
Never made you party in the writ proceedings?
We are not parties in the writ proceedings.
Who was for the petitioner at that point of time?
Well, it's
Ajitul Sheikh, my lord.
Ajitul Sheikh.
The counsel of the petitioner.
Mr. Hassan.
Mr. Hassan, and these facts was never narrated in the petition, my lord.
Lordships, I was quite aghast with the kind of prayer that was made, because it's otherwise a very innocuous kind of a prayer which would have been granted. At page 22, your lordships would find the prayer of the writ petition.
Yes.
Well, it's to conduct the demarcation of the petitioner's land covered by patta number so-and-so, dated so-and-so, at so and so in terms of the order dated 13/10/2022. It was almost like in my lords executing the orders of the revenue court before this honorable court with an allegation that I have somehow.
That's the only thing that yes, that they were being obstructed against the. So as per the report of the Mozadar, I think,
yes.
that he was being obstructed.
Balance.
That is
Balance.
Anyway,
delay is there of 5 days. Notice has to go to the private.
but then what will happen to the?
That my lord, if there is a prayer, my lord can only pass necessary order.
We can't pass any orders until the matter is admitted.
Let's delay, but in my humble submission would not come into play because considering the fact that I was not a party, it is only because by way of abundant caution.
Yes.
But a separate application is
Which
also not
case?
filed, my lord.
What? For condition delay?
No, my lord, for the interim.
Separate application is not necessary. Otherwise.
So, Miss Review Petition, Miss Case Revision number 3/2023. So this is an application for review of the order dated 24/3/2023, passed in WPC number 482 of 2023 by this court. Like the ground is set out in the applications that the petitioner was unaware about the earlier proceedings, and as such, in so much as he was never arraigned as a party, though he is vitally interested, and as such, the delay, if any, may be is subject to delay be any be condoned. So, Mr. S. Day is present on behalf of the official respondents. Respondents number 1, 2, and 3. Stop. Considering the nature of the prayer and the grounds as made out of the delay of 5 days is hereby condoned, and the matter is taken up for consideration. Review applications taken up for consideration. Next, in the main case, review application, in view of the order passed in this case, so and so. This the review petition. Issue notice on review petition to the private respondent. Matter to be listed after steps to be taken within 2 days. Matter listed after 2 weeks. In the meantime, no demarcation shall be undertaken by the respondents, which were directed by order dated.
But it's 24/3/2023.
24/3/2023.
Hallelujah.
Till 10.
This is this NIT matter, my lord. As of now, there are 3 writ petitions, my lord. In one of the matters, you filed affidavit. In 2 more, we are yet to file affidavit.
This one you filed?
This
My
one,
lord, this one they have not filed. My lord, on the last occasion, my friend had submitted that he will be relying on the affidavit filed in WPC number 214.
that is also listed to item number 28.
So we'll take it up now. Or what? Any effective order is necessary today?
Hello?
Is it for disposal today, or what do you want?
It's fixed for hearing. My lord. The other one is fixed for
We'll hear the other matter. Up to you. I mean, up to the parties. If you're going to depend, this matter also can be kept together. If you are going to, on this matter, you're going to rely on that other affidavit, then we can put a process for hearing together that matter.
My lord, if the entire matter is heard, it will take some time, my lord. But what has happened here is, my lord, there are 2 orders which have been passed. My lord, there are vacancies in the concerned departments.
Is there a direction not to fill up, my lord?
There is a direction not to fill up the post, my lord.
So it's all in your interest to
Yes,
the matter be heard earlier.
Yes,
so what we'll do is we'll list this matter hearing together 28. Since you won't be filing affidavit in this matter.
They will not be. That is what they say, my lord. They will not be filing affidavit.
Dr. N. Mozika learned it, DSI for 1, 4, 5, and 6. Submits that as.
My lord, may I pray? Since your lordship is fixed, because what happened, my lord, there is the previous director is retired. New director has been selected. My lord, the appointment orders have not been issued till now. And only.
No, we'll list it together. I'm not saying we'll hear it today.
My lord. So, my lord, what I was praying that instead of closing the affidavit, my lord, if till by next date I can get some instruction.
Okay.
There was this submission earlier that they will not be filing affidavit. I believe it is reflected in the previous order, my lord.
He says that Learned Counsel respondent number 4 submits institution still without a director and please be able to rely on affidavit filed on similar lines. He doesn't say that one file. Anyway, Dr. M. Mozika, Learned DSGI for respondent 1, 4, 5 and 6 submits that as the new director is about to take over charge of the institution, he prays that the matter be adjourned for
2 weeks.
2 weeks.
3 weeks.
3 weeks. Therefore, 3 weeks to be able to obtain full and complete instructions.
Listed along WPC number 214, which is
as item 28 in today's list is connected, list his matters together after 3 weeks.
And the interim orders will continue.
The interim orders passed shall continue until next day.
11.
Yes, Mr. Sama.
Lordship,
You file affidavit no, on behalf of Carvils?
Not
You don't want to file affidavit? Nearly 1 month ago. Let's see. You file. Mr. Counsel?
Yes, it is there. Only private respondent yet to file.
How many times you prayed?
The last occasion was so day.
3 weeks time was given. Anyway, Mr. Eskerium, you're for Eskerium, correct? For respondents 4 and 5, submit that translations are not complete. He prays that it be allowed further 2 weeks time to complete the same file affidavit. So prayers allowed just after 2 weeks. No further time. We're just saying. Yes.
Much less possible.
May it please your lordship.
Yes.
Lordship, I pray for 3 weeks time to file rejoinder in this matter, my lord.
How many times you asked for rejoinder?
Just once, my lord.
MSP Agarwal prays funds allowed for the 2 weeks time.
My lord, actually the
3 weeks
petitioner
time
is
for
in the
rejoinder.
defense. He might
3 weeks time.
13.
oblige, my lord.
Yes.
May I please, Your Lordship? Your Lordship, I will be allowed some time to file the affidavit in opposition.
What about your respondents 5 to 7? MS Esbarat Shaji in behalf of 1 to 4, Mr. and Mr. C.H. Thomley 5 7, pray for granted further 2 weeks time to file affidavit. Yes, thereafter and so and so.
14.
Item 14 is.
1 second, let the file come.
Sorry. My apologies.
Same petitioner.
Yes, Lordship. Lordship, out here in the previous item, they were challenging the inquiry report of the government, and in this petition, they're challenging the order of termination.
So what you're pursuing both writ petitions? Where's Mr. Sheikh? 5 and 6.
5 to 7.
There's no 7 here, I think. 7's here.
No, Lordship, there's only 6. 5 and 6.
When will you file affidavit?
After 2 weeks.
Lordship, I pray for 2 weeks time to file.
Wait, you can run along on behalf 1 to 4, Mr. Thomley, behalf 5 and 6 are granted 2 weeks for a time to file affidavit. This thereafter, this on so and so together with the earlier case.
15?
Yes. Much obliged.
Instructions you have received?
No, we received the amount. So
What amount is this?
Gratuity amount.
gratuity.
Then Mr. Swami submits that the order has been complied with. Stop. As nothing is left, nothing survives consideration, the contempt matter is closed.
16.
This is the matter where the Lordships on the last occasion had directed the District Council to provide instructions with regard to that NOC matters.
Drilling? No.
I'm sorry, Manoj.
Oh, sorry. No, sorry.
This is with regard to that Manoj, land acquisition.
Lordship was inquiring whether the District Council is required to give NOC. If we are going to peruse section 41 of the Act of 2015, definitely because the land is located in the autonomous area, we then SSB, Your Lordship, we need some more time because I'm supposed to get some instruction on the entire matter, what exactly has transpired. I need some more time, say another 2 weeks.
You have the act?
Yes.
Sorry.
Yeah.
This land is it's a
right land.
Right land. It's not individual land.
No.
What about state?
May I please, Lordship, I'll be requiring some more time to find my account.
You come with specific instructions, Mr. Kanta.
Yes, Your Lordship. According to me, the petition is not maintainable. We that as it may.
Whatever you have to see, you see an affidavit.
I'll bring some.
Insofar as we are concerned, Malaj, we are only referring to the proviso to Malaj, Rule 3, Paragraph 3 of the 6th Schedule. Malaj. There is a specific provision, Malaj, that in such cases, the no NOC from the District Council is required.
Proviso section to Paragraph 3?
Yes, Malaj. If I may take your Lordships to the proviso to Paragraph 3, Malaj. And this fact we had pointed out to the state respondents. If your Lordships have it, well, may I read?
Yes.
Well, it's power of district council and regional councils to make laws. The regional council of an autonomous area in respect of all regions within such region and the district council of an autonomous district.
Nothing will prevent compulsory acquisition, you mean? Another proviso.
Provided that nothing in such laws shall prevent the compulsory acquisition of any land, whether occupied or unoccupied, for the public purposes by the government of the state concerned in accordance with the law for the time in force, authorizing such acquisition. So, well, it's the power of the district council insofar as mandatory acquisition of land is concerned, Malaj, has been taken away by the constitution. So, in the face of this provision, Malaj, the state authorities, Malaj, out of the blue had then written that there has to be a no objection from the district council.
Let's see the act. I have the right to fair transparency.
Section 41.
41 of Lordship.
Yes.
41 what?
41(3). May I read, Lordship?
3. Yes.
In case of acquisition or alienation of any land in the scheduled areas, the prior consent of the Gram Sabha of the Panchayats or the autonomous district councils at the appropriate level in the scheduled areas under the 5th schedule to Constitution, as the case may be, shall be obtained. And in all cases of land acquisition in such terms, including acquisition, in case of any urgency before any act under the issue of any notification under any other central act or state act for the time being in force, provided as the consent of the panchayats or the autonomous district council shall be obtained in cases where the Gram Sabha does not exist or has not been constituted. This is in respect of the 5th schedule, Malaj.
Yes.
Because the 6th schedule, Malaj, makes that proviso is available.
Without as it may, I'll give obtain the instruction. Because according to my information, the matter has become infructuous because BSF have already availed alternative site for setting up.
Not to our knowledge, my lords.
I have the information with me. Due to some problems, I could not obtain this.
May please, Your Lordship. In that matter, also, if the BSF can be made party in this petition, Your Lordship.
Why should it be a party?
It is purely, we are before your lordships only against the pure action of the state.
He is the master of the brief. He can, if he doesn't want to make party, it goes to his detriment. That's up to him.
Lordship.
Yes, Mr. H. Harwanlang for respondents number 1 to 3, and Mr. Vijay Kantan also for 1-5 play for allowed. I'd make it 1 week time.
Within a week's time.
1 week time for further instructions or affidavit. It's only a point of law. There's nothing less after 1 week on some signs.
17.
May I please, Your Lordship? On being instructed, my lord, as per the last order, I've taken specific instruction. I was instructed, my lord, if my lord permit us 45 days time, will clear his.
2014 bill.
Sorry, my lord.
That's 2014 bill, correct?
Yes, yes.
That's the one, correct, Mr.
This is not bill, yes, this is money that 5 lakh 26.
This is what?
That is a gratuity one.
Oh, not the construction one.
No, not the construction is already paid.
When 45 days, close it. When 45 days.
Yes, yes, my lord. My lord may record my submission.
Yes, Mr. S. Deb submits instructions and undertakes that the respondents shall clear the due the DCRG amount of the petitioner within a period of 4 days.
45 days.
45 days from today.
Lordship.
Yes, on this undertaking, the matter stands closed and disposed of.
Much less.
18.
Oh, this undertaking is accepted. Matter stands closed and disposed of.
Much less.
Number 1, 2, and 3. So I need to.
Who's for the petitioner?
Yes, Mr. S.
Oh, the other SN. Where's who? I mean, who's the petitioner? Where is the petitioner? You are appearing for whom?
I'm entering appearance on behalf of respondent 4 to 8.
4 to 8. 4A, all of them. Yes, Mr. M. Chanda. Oh, sorry, S. Chanda. Today has entered appearance on behalf of respondents number 4 to 8. What about 9? 9 is whom?
Private respondent was being selected.
Yes, a service report on behalf of respondent number 9 has not been returned. Stop. Yes. Will file affidavit?
My Lord,
Yes.
My Lord, I'm appearing on behalf of proposer respondent number 11.
Yes, MSP Agrawal is also present behalf. UGC? Yes,
Yes,
present
my Lord,
behalf.
I have been appointed as panel.
Yes, Mr. Bdev was there, yeah, is present behalf of
Yes, my
respondent
Lord.
11.
The appointment has subsequent to that.
And MS Esrum Thao for number 10. Stop. Apart from respondent apart from number 9, all the other respondents have been served. Stop. None appears for the petitioner. Next paragraph. List after 3 weeks for service report of affidavit by other respondents. Service report and respondent number 9, and for affidavit by other respondents. Yes.
19. 19.
Yes, yes, Mr. Khatiyan. What instructions do you have?
These are just mere allegations, Your Lordship.
Correct. Then we do have affidavit. Instructions means what? Instructions not everything being mere allegations. What is your prayer here? That they blocked you blocked the mere allegations.
They blocked my ingress and ingress, Your Lordship, and after that, after I filed a suit, then became enriched.
Yes, that is what, of course. Otherwise, you have to appear here.
Until now, Your Lordship, we are facing the same problem, Your Lordship.
Same problem?
Yes, Your Lordship. Every time, Your Lordship.
What's your name? Mr. Amarwan, another counsel for respondent number 4, submits that he has no instructions, only that the allegations made by the writ petitioner are incorrect. So on that view, the matter is directed to file within 1 week. You file affidavit within 1 week, inasmuch as the petitioner submits that they are still being given hostile treatment by the headman and other villagers. What do you submit last time, Mr. Kintai? said that let them come
for
for
a representation before us.
let them file affidavit first. We'll put things quieted down, then let it is just after 1 week.
Right.
Hearing, item
Especially
20.
that ingress and egress is being.
That matter is pending in this Council, Your Lordship.
No, that's all right. But even then, the other thing is that they can't take away your rights.
Yes. All right.
Yes.
Yes, Mr. Kumar. As per the last order, my lord, we have prepared the bullet points. And due to sudden ill of Mr. B. Pathak, we could not come down today, my lord.
What submission do you have to make? It's been heard.
But the matter was heard on last occasion, my lord. You know, this is the contempt application since pending since 2015, my lord. 8 years down the line now. And our submission.
Where are your bullet points? You prepared?
Yes.
Give it to the court master. Your submissions are there, correct? You've recorded submissions there. What do you have to say? Bullet points submitted by the counsel of the parties. Matter reserved for judgment, please.
21.
Yes.
21.
This matter is again similar matter as
So 20 will cover 21 also.
20. We also may be allowed, my lord, some time to. Since your lordship has already fixed it for judgment.
Same judgment will cover this also.
We will have our own.
But basically, they have to come by way of a fresh request. Maybe
Let them file bullet points and then.
Grant us some time.
Earlier, filed with the same but taken on board for reserve judgment. Stop. As item number 21, that is Contempt case C-19/2017 is along similar lines. Ms. S. Thapa, counsel of the petitioner, has made a submission that he may be allowed to file bullet points in this matter. So, prayers allowed at least after, I will list it again after 1 week. 1 week for filing bullet points by the parties is together with Contempt case number 23 of 2015.
22.
Ready? Who's your senior? Yes,
Lordship, in this case, the newly implemented respondents who approached the Honorable Divisional Bench.
Who approached the?
Divisional Bench to set aside, because this case was disposed of by the Supreme Court on the basis of the inquiry conducted by the directors pursuant to the order passed by this court. The case was finally disposed of. On being agreed, the newly respondent, they approached the Divisional Bench saying that I was not heard in this case and not a party. So I am affected by the judgment. Now, if the newly implemented respondent starts the case, what he wants to say? Because
where's order division bench? Okay, this is here, right? Okay. So one number 6, before division bench was whom? That's one number 6.
6, yes.
Who was one number 6? MK Sa appeared for whom? Mr. Siddiqui, that means.
Mr. Siddiqui.
Where is he here?
My lord, I didn't see him today. He's one of the main party.
He's the main party. Because
Where's the Nyota you was here just now?
Well, since he's not here in the main party, may I request the matter come up next week?
Because this was instituted by Mr. Siddiqui.
Yes.
It doesn't matter. So where's the? He was here just now. Where's he? Where he disappeared? Mr. Siddiqui is here. Then?
I apologize, we missed the cost list.
What do you mean you missed the cost list?
We didn't see your leadership. I apologize for that, leadership. I just prayed like another Vatican after 1 week, leadership.
Yes. When this matter is taken up, Mr. D. Nyota please that the same be adjourned in the absence of his senior. In conclusion, next one thereof, this matter after 1 week.
23.
This is your lordship. Mr. Bora is on leave.
As Mr. Baran sanctioned this matter after 2 weeks.
24.
Yes. Court already forgotten about the matter. We're pressing for hearings. Last time you avoided very
No, I'm not
in a very agile manner, and so that the court also lost track.
The matter will be disposed of, but subject to my senior.
In a very agile manner, he sidestepped every attempt to solve the case.
Maybe the matter was heard on so many occasions, but could be
That's why I'm saying in a very agile manner. We have to give you credit for that. That is part of advocacy also.
Yes.
Like keeping a patient on ventilator. Like that. Yes. You want to dispose which way you said?
There's no substance.
There's no substance, yes.
No, my case, Lordship, the application which I filed, because the
yes.
The mother of the petitioner died on 4th January 2015 at GNRC Hospital, Guwahati.
Yes.
Then the application was filed under Order 22 Rule 3 CPC, allowing the applicants to substitute the claimant on behalf of the deceased claimant in the instant suit. This is Annexure 1 is an application file before the trial court. The London Trial Court District Judge, White Order dated 17/4/2019, Annexure 15, disposed of the matter on the ground that the application is barred. Annexure
4.
Annexure 4. Annexure 2 is the judgment, an order passed by the London District Judge.
Annexure 2?
Annexure 2. Page number 14. Page 14.
Okay.
The order says
17/4/2019.
17/4/2019. It says that the applicant Nixon Nungrum has filed an application under Order 22 Rule 3 CPC, which has been registered as petition number 23/2/2016, inter alia praying for substitution of the claimant in the arbitration case, arbitration number 2H/2015. The applicant has projected himself as the son of the claimant. It is not disputed that the Limitation Act is applicable in the arbitral proceeding as per the statement of the applicant in paragraph 4 of the petition. The claimant died on 4/1/2015. The instant substitution application was filed on 22/2/2016. The period of limitation for the substitution application starts running from the date of the death of the claimant. In the instant case, the time started running from 4/1/2015. The period of limitation for filing a substitution application commences from the date of death of the persons, and Article 120 of the Limitation Act 1962 provides 90 days for the filing the substitution applications. In the event the substitution application not being filed within the limitation period, the consequence is that the suit gets abated if the right to sue does not survive. The suit gets abated automatically without any judicial order from the date of the death of a person. Article 121 of the Limitation Act 1962 prescribe a limitation setting aside the abatement. The time period prescribed for the setting aside abatement is 60 days from the date of abatement. In the case in hand, the proceeding of arbitration case number 2H/2015 stood abated after the expiry of the 90 days from the date of the death of the claimant. 4/1/2015. The proceeding of the arbitrations case number 2 stood abated on 4/4/2015. The instant application was filed on 23/2/2016 without any application for condition of delay. This application is barred by limitation as there has been a delay of 325 days. The application is still disposed of. So now we found that we did not file an application
for setting aside
the abatement as well as for the limitations.
You didn't file for condemnation.
Condemnation also we have not. We
didn't file. You didn't file condemnation. You didn't file abatement. You filed straight for substitution.
Straight for substitutions.
And that means the matter abated after the death of your mother on 4th of January on 15. Matter stands abated. Right.
Abated.
Okay, fine. And then you didn't file, and you came on 23rd of February 2016 with an application for substitution. Okay, when it should be the last application to file. Yes.
Now, this is the two defects. We did not file an application for abatement. And
no abatement.
And the application for condition of delay also not filed.
Yes.
Then, since it is not barred by under any law for filing a subsequent applications, then again we file an applications for setting aside the abatement as well as for condition of delay. So this is an petitions, page number 17, annexure 3. This is the application we filed. Though it's a composite application, but
how can you file composite application?
Only one. This is the
how can you file composite application?
This is the first time I filed. When we found that the case was barred by limitation, an application for setting aside abatement was not filed. So to cure the defects, we filed
once under the CPC, the Laws and Limitation Act. Then you can file in the same application.
No, now we have filed an application for setting aside the abatement as well as condoning the.
In one application.
In one application.
Page 17.
Page 17. Page 17.
Where?
So page 17. If I may read the.
Yes. Can you read?
An application under Order 22 Rule 9 for setting aside the abatement of arbitration case by condoning the delay of 1426 days as provided under Order 22 Rule 9 CPC Red B Section 5 of the Limitation Act, as the application was prevented by sufficient cause and reason for not bringing the name on record for substituting his names in place of deceased plaintiff in arbitration case number 2 of 2005 in time after the death of the petitioner, now deceased, who died on 4th day of January 2015 at GNRC Hospital. Then we, in the same application, we said an application under Order 22, Rule 3 CPC 4, allowing the applicant legal heirs of the deceased petitioner to be substituted in the arbitration case number so-and-so pending procedural court. So this is an application file. But this application was in fact not considered by the learned trial court. Trial court simply passed an order without giving any reasons, assigning any reason why this petition is not maintainable on the point of law. This is Annexure 4, page 26. It says that 2/5/2019, the order was passed. Hard learned counsel Srimati K. Chisa for applicant. The applicant has once approached this court by filing the instant miss case inter alia, praying for setting aside the abatement and condoning the delay for setting aside the abatement. The applicant had earlier approached this court by way of an application under Order 22 Rule CPC. The court, vide in Order so-and-so, dismissed the substitution application on the ground that petition was barred by limitations. In view of the order dated 17/4/2019 passed by this court, dismissing the substitution application, this application for setting aside abatement is not maintainable according to no reason was given by the trial court. Why?
What reason necessary? When setting aside abatement, when your substitution has been dismissed?
Dismissed. At least the subsequent application, whether it is hit by
why did you withdraw the earlier application then?
Whether
Yes.
it is hit by res judicata or hit by any other law, at least some reason to be given why this application is not maintainable, subsequent application is not maintainable when it is not barred by any law.
Okay.
So just by my case only, if this order is set aside, if the matter is remanded back to the learned trial court to decide afresh, to hear the matter and decide the matter on merits, and
Yes.
that is my prayer only.
Yes, Dr. Muzika.
My lord, the earlier application was rejected on the ground that there is no condonation application.
Yes.
So what was rejected was, my lord, the main application, the substitution application itself, my lord. Now, once a substitution application has been rejected, my lord,
Yes.
a second substitution application, and the second application is not even a substitution application, my lord. The application itself is so misconceived, my lord. The prayer portion of that application, my friend has not referred to that, my lord. He has 3 prayers in the same application, my lord.
Oh, he asked again substitution again.
3 things he asked for, my lord.
One, condemnation.
Condone the
Two is
delay of 14
abatement.
26 days.
And also substitution.
Set aside the
Condemnation.
abatement and substitute the applicant, my lord.
Yes.
So they are 3 separate things, separate causes of action, my lord.
Yes.
You cannot combine these 3 things. And moreover, the learned trial court is rightly held, my lord, it will be hit by res judicata also, because earlier substitution application is already.
That's clear. Why do you make it kind of prayer then, Mr. Qureshi? You couldn't win. Why would the appellant not file a separate application for condemnation? And the thing is that court can go as first appeal. It seems there are no grounds for delay. Why delay? Is there nothing?
This one, it was not filed. Or
It was not filed. No. You just see. See where read para 15. Of your application at page 21. Read from 14. Nothing is new. You see, a limitation, even if we are to take this condemnation application at face value and say, yes, consideration, can this application be considered?
Paragraph 15, Lordship, regarding this, now the delay up to 114 days for filing an appropriate and proper application for setting aside. So the question of law is involved only whether it hit by.
What question of law? No. I mean, like, you look at this. Look at this. We're sitting first appeal. Remember that it's not a second appeal, or we're sitting in first appeal.
It's
correct?
a first appeal.
Yes, it's a first appeal. Correct? Is that a first appeal?
It is a first appeal.
Yes,
it is a first appeal.
Yeah, because it's been dismissed. Your entire on the ground substitution, your entire your entire Section 34 application has gone, has abated. Correct. So you've come against an order of abatement, or you've come,
No, we
against
have come before the court.
You've not come against order of abatement, correct?
No, we have come.
You've
before
not come
the
against
court.
order rejecting a substitution, correct?
We have come before the court, Lordship, because my application was not considered on merit. It was not considered on merit. Suppose if
How can you consider merit? That order still remains. The order declaring that your Section 34 application has abated with the death of your predecessor interest, and so there's no. You never filed for setting. It doesn't come together, right?
Subsequently, I filed the application before the same court, but at least we're expecting that some order could have been passed on merit, not to straightway rejecting the applications.
Not maintainable, my lord.
No, maintainability is there. How is not maintainable? I do not know, because Section 11 res judicata will not be applicable in this case.
Why not? Neopriya?
It should not be applicable.
Why not be applicable?
Because the matter, the courts of if any application filed without an application for abatement, first we have to get the abatement satisfied.
No,
before
Mr.
that also we have to get.
You have what you have done is that instead of going to the head, you start from the tail. Okay, for substitution. Now what you've done is that now your application for substitution was rejected.
Rejected on the ground, not
fine,
on the merit.
Fine, it's rejected. It stands rejected. Correct. For whatever reason, it might be for A, B, C, D reason. It's been rejected. Okay, you just keep that in mind. Now you come again substitution application to try to correct, but again you file for substitution.
No, substitution will be.
Why do you file substitution again then?
Ultimately.
No, why do you file substitution again?
Lordship, in the
See,
event.
you have not corrected the earlier. What happened? The earlier one is dismissed. Then you've come again in one application with 3 prayers. Condone the 1026 delay without ascribing any reasons at all for the delay. Then set aside abatement due to the council's fault. And you came after your mother died in 15, you came 16, and then the third one is for the prayers already been rejected, you said substitute me in place of the deceased your predecessor.
The substitution application was not rejected on merit, that I am not the son or I am not entitled to get substituted. The substitution application.
Rejection can be. That's why this court said for A, B, C, D reason can be rejected. Doesn't mean rejected that because you're not a son. Nothing. It just says that the suit's abated. You have not filed any application for abatement for setting aside abatement. There's a huge delay. There's no application on board for condoning delay. So, on that view of the matter, your substitution application is not maintainable also in the face of it.
No, it is barred by limitation. It is
barred by limitation. Even you look at the whole picture.
Court declined to decide the application of substitutions on the ground that since it is barred by limitations, we are not going to decide the applications.
So now what do you have to say? Anything else?
No, Lordship, we want to say that the application which I filed, if it's a question of law is involved. Suppose
now your substitution has already been dismissed.
No, substitution is not dismissed on merit.
Then where's the challenge to substitution, to the order of the order dismissing substitution application?
We have it may be kind of chaotic petition. We just file an application that this is the defect. We want to cure it.
See, you're never interested in pursuing it. It's just afterthought. What is the amount of the award that was not given to you? You claimed how much? What claims were there? What is the value of the contract?
It's a contract.
And what are your claims? What contract was it?
Few lakhs.
What is the contract for? Which construction?
Postal department.
Is it construction now?
Construction.
So the arbitrators they rejected.
Both the parties were agreed by the.
No, I mean your claims were rejected.
My claim was rejected. Even they also filed. Some claim was given to us. Even they also filed an application.
Now what happened with the application?
Their application they did not pursue. Their application was also dismissed.
So you also dismissed. So be happy like that, only. Yes.
My application case number 2 and 3 is filed by the Union of India, challenging the same award.
Then we leave it at that. Yes. Heard Ms. M. Kurishi, counsel for the appellant, and Dr. N. Mozika, the GSCI with so and so for the respondent stop. The appellant being aggrieved with the order of the District Sessions Judge dated 17/4/2019 before this court on the grounds that the said application of the appellant was dismissed by the where's the order by the
Yes, 26 months imprisonment.
by the court below without the merits having been gone into. Stop. Next paragraph. The learned counsel of the appellant submits that the predecessor interest of the appellant, who was his mother, had filed an application under Section 34 of the Arbitration Conciliation Act 1996 for setting aside an award in arbitration case number so and so, dated 23rd March 2005. Counsel submits that his mother expired on 4th of January, Mr. Kurishi, 4/1/2015. And after lapse of some time, on 23/2/2016, the appellant had filed an application under Order 22, Rule 3 for substitution. Stop. However, he submits the same was dismissed on
17/4/19.
17/4/2019 17/4/2019 on the ground that the same was barred by limitation and that no application for correction of delay had been filed by the appellant. Stop. Thereafter, he submits the appellant then file a consolidated petition for setting aside the abatement,
Condonation of delay.
condonation of delay, and also for substitution in the said arbitration case, which by order dated 30/4/2019 was dismissed.
2519, 2519.
2519 was dismissed in a most cryptic manner. Without going into the merits of the case. So he submits that the order being bad in law is liable to be set aside, and the appellant allowed to, and the law court directed to take up the application for consideration and to pass orders on merits. Correct?
Yes.
Yeah. Dr. N. Mozika, learned DSGI, appearing for respondent, has submitted that the order dated 17/4/2019 passed by the lower court dismissing subsequent application remains and stands unchallenged. And as such, the arbitration case having abated and no substitution being allowed, nothing remains for consideration. Stop. The Legislative Council has also contended that the application in this form is also not maintainable, and as such was rightly rejected by the District Sessions Judge. That's it. I have heard the counsel for the parties. It is undisputed that the substitution application by the appellant was filed after a considerable delay of 325 days, for which no condemnation application was filed. Further, sorry. Comma, and as such came to be dismissed by the order dated 17/4/2019. So, a perusal of the application filed on
30th April 19.
30/4/2019 shows that it is in an, can you use an omnibus fashion? Is it made in a consolidated fashion, whereby 3 prayers have been made. 3 prayers have been made. That is for condemnation of delay of 1,426 days, comma, for setting aside of the abatement of the arbitration case, and also for substitution of the appellant. The contents of the application, apart from re-agitating a point regarding a prayer that already stood rejected, and also apart from the fact that no explanation has been offered for the long delay, nor for any ground made out for setting aside abatement, comma, though the order of the 36 Sessions Judge seems to be cryptic, no interference is called for, inasmuch as no defense is called for. No defense is called for by this court. So it is also noted that the substitution already having been rejected, the application also was barred by the principles of res judicata. And as such, the following prayers could not have been entertained in any manner. So, for the aforesaid reasons, there being no merits appeal, the same is dismissed and disposed of.
27.
Yeah, please, Your Honor. my learned senior, he's on his legs and is in the DB.
It's an arbitration matter.
Arbitration,
My
no.
lord, yes, Mr. Yobin is the counsel who is leading this matter. So he has also informed that he will be tied up in DB, my lord.
What is the matter about?
My lord, is regarding the...
Pension?
Not exactly pension, my lord.
Claiming parity.
My lord, parity with regard to those, my lord, who has been on the...
Okay, when do you want it then?
After a week.
My lord, on regular course, my lord. There is... I don't see
Regular course will come tomorrow.
For my friend's convenience.
Yes, as the Army Council is not available presently, this is a matter of the 1 week. Yes.
Obliged.
31.
Please, Lordship.
Start.
Lordship. My senior is currently on leave, so I pray that this matter may be come after 1 week, Lordship, next week. He has some part out matters.
Yes, senior counsel available. This is matter after. The available court presently is matter for 1 week.
1 week.
32.
Yes. What is the problem? Is that available online also? Mr. Datta, what's happened?
Your Lordship, because the last date order, it has been reflected that this matter will be listed on 17/5, Your Lordship. So he was under the impression that the matter will be listed.
Yes, we won't take it up today since there might be some, because there was not recorded last order. I'm going to mention. Stop. This matter has appeared today on a special mention being made by MSB Kharwanlang on earlier date for upgradation. Stop. As the counsel for the respondent was not informed about the, will you inform him?
We have informed Your Lordship.
Just today, Your Lordship.
We informed him, Your Lordship.
That day only. Yes, your name? Efnorum?
Miss P. Retam.
Mr. P. Retam, as on mentioned also by Bikharana Stop. MSP Raitham, appearing on behalf of Mr. S. Datta, submits that they were not informed about the rescheduled date. And she prays the matter be taken up the after tomorrow. Prays the matter be taken up the after tomorrow.
Lordship, the local council may inform the...
Yes. No, now it will come in the order sheet. Yes, we have tomorrow. Yes. On the prayer of so-and-so. This is matter to tomorrow. It's expected that on next date, Mr. S. Datta will be present.
33.
Yes.
The conducting counsel, Mr. Vipathak, is in disclosure today, so this matter may be taken after 2 weeks now.
Yes, as the Army Council said to be indisposed, this is matter for 2 weeks.
35.
Yes, Mr. Rahman.
Yes, sir. I had already given the rejoinder, but I don't know why it's not reflected. Opposite party also had received.
No, rejoinder, you said you will not file. That's what Mr. Bora, or who said last time. You had submitted last time, you won't file rejoinder. You want to file rejoinder?
No, I had already.
There's no rejoinder?
Already.
No rejoinder, say.
Oh,
you already filed, yes. Oh, yes. On 30th, that is on day before, last week, yes. Okay, yes, you start. What is your grievance?
Grievance is that my client, he should be given the job because he's a family man. and then the dismissal order should be.
No, you have to tell the court why does the petitioner feel the dismissal order is wrong. Why does he feel it's wrong?
Dismissal.
Now, if you can show the court that his dismissal is wrong or irregular or illegal, then your petitioner will get the benefits.
Okay, so the sudden jolt of arbitrary and unlawful act of respondent shattered his life, and without following any procedure in accordance with the law, thus the respondent has infringed fundamental rights of the petition under Article 14, 16 and 21 of the Constitution by the illegal and arbitrary termination of the petitioner's job, and having no other alternative, the petitioner is before this honorable court with his petition under Article 226 of the Constitution seeking adequate remedy.
No, what's wrong with the order? You're saying yes, your contention is that the dismissal order is arbitrary, is wrong, it's illegal, is violated Article 21, 14, 16. Why is it wrong?
It is wrong.
Where's the dismissal order? Let us see the dismissal order. Where is it? The impugned order, where is it?
Page 14, dismissal order, and page 15.
Yes, you read it. Type copy is at page 15. You read it.
15. Arrest number G50058583, rank rifleman, general duty and Pule of 3 NH Battalion, Assam Rifles, was admitted at King Hospital, Kohima on 26 October 2018, and individual absented without leave from King Hospital, Kohima, with effect from 26 October 2018 at 15 hours, and still so absent without any information. And he informed, but due to COVID, he was not allowed to enter.
In 18, COVID was not there.
18, but he recovered quite late.
No, see, you read, whereas so-and-so, so the petitioner was admitted at King Hospital, Kohima,
yes,
on 26 October 2019. And the individual absented without leave from hospital with effect on the same day admitted, you ran away. Okay. And 26 October 2019 at 3 o'clock, and as on 27 October 2021, still absent. That means you're absent for 3 years. 18 to 19, 19 to 20, 20 to 21. That means 3 years you're absent. From 26 October, this is 27 or 21, from 26 October 2018. Now, COVID had not come that time. COVID came only 2020. It said COVID-19, but COVID came only in
2020.
Yes. So, how he got COVID before that time then? From 18 to 20. So, that excuse will not stand. Okay. Now, whereas after expired 30 days absence, a court inquiry on Section 84 of Assam Rifles was convened, dated 30 to investigate into the circumstances. This date is wrong. It's was convened on 2019, it should read, to investigate the circumstances under which so-and-so absent of leave. And whereas an apprehension rule so-and-so was issued and forwarded to police to his place to apprehend him. However, till date, neither the individual could be apprehended nor has he surrendered to any Assam Rifles, because he is still absent. A total of 3 years has elapsed since his absence. And whereas as per paragraph so-and-so, he was informed about, the mother was informed about the police absence. However, no intimation from individual next of kin. And that is why they were dismissed from service. You disappeared for 3 years.
Not exactly 3 years.
Yes.
He tried to come to the department.
You have to show where he tried.
Not allowed.
Show. Did he write any letter?
Yes. Verbally.
Verbally.
Yes. Because he's a rifleman only, he's not very educated.
Where is he now?
He is in Nagaland.
What is he doing?
Mon district. He is not doing anything, sir.
He is doing cultivation.
He is just waiting for this to come back to service.
How many years did he serve before he deserted the force? He was appointed on
2005.
2005. He served for 13 years.
Yes.
Yes, Dr. Mazika.
3 years is a desertion of service, my lord.
When was he appointed?
Well, he was appointed on 17/4/2005.
For long years he served.
He served for 13 years, my lord. Then once he was admitted in hospital on the complaint of dysentery, my lord, and from the hospital itself he disappeared.
Sorry, Ms. Rahman. Hopeless case.
So please help his
But you've tried, so that's. Yeah.
Otherwise, what he will do with
What he'll do now? 3 years he should have realized.
4 children. Then he got mother also, parents also, old age.
Take down. Heard the counsel for the party stop. The petitioner is before this court being aggrieved with the dismissal order dated 27/10/2021, whereby he has been dismissed on a ground of desertion from service under the Assam Rifles rules. What rule is it?
But it will be section 11(2) of the Assam Rifles Act.
That's section 11(2) of the Assam Rifles Act 2006. Stop. Next paragraph. MS S. Rahman, at counsel of petitioner, submits that the petitioner had entered service in the year 2005, and the reason for his long absence was due to reasons beyond his control, as he was very ill. And though we want to call that, and though he had verbally contacted the authorities, he was not afforded any relief. Stop. She praised that as the petitioner is a family man with a family support, the respondents are liable to be directed to consider his case sympathetically so that he will be taken back in service. Stop. Next paragraph. Dr. N. Mozika, learned counsel for the respondent, submits that the writ petitioner had absent on being admitted to hospital on account of dysentery on the 26th October 2018, had on the next day itself absented himself, without any information, for which a court of inquiry was instituted. He submits that on completion of 3 years of desertion period, the petitioner was then dismissed from service with effect from 27 October 2021, by dismissal order dated 27/10/2021, issued from the headquarters in compliance with the rules under the Assam Rifles regulations. Stop. He further submits that this being a clear case of desertion and the petitioner being absented without intimation, the punishment of dismissal is just and appropriate. So, what about the money recovered from him?
My lord, in amount of 40,000 something, my lord, there was a case of overdrawn by him. So we've written to him, but it seems that he has not deposited that.
So let that go.
That can you?
Yes. Stop. Having considered the matter in its totality, stop. The fact that the petitioner was absent for 3 years without intimation is apparent and has not been rebutted by the writ petitioner himself. Stop. In such matters, the writ petitioner, who is a member of the discipline force, who is expected to maintain a standard of conduct and discipline which is higher than other services, the absence has rightfully not been, his absence rightly resulted in his dismissal from service. Stop. As such, as much was further, no materials have been brought on record to substantiate the grounds taken that the petitioner was prevented by sufficient cause from attending to his duties. Stop. Next, but there being no merit, next para, in the petition, the same therefore deserves no consideration and is accordingly dismissed. However, in consideration of the prayer of the learned counsel petitioner, was submitted that the writ petitioner is in acute financial difficulty. The order for recovery, the order for recovery of excess pay and allowances shall not be for excess pay and allowance dated 7 March 2022 shall not be acted upon. So, with your force direction, petition stand disposed of. So that money you don't have to pay. That's the only thing you can help your client. Yes.
He will not get back to job.
Yes?
Job.
No, a job, how will he get back? Yes.